Good morning. It's great to have you here, Ashley. Thank you very much for joining me. And good morning, everyone. Good morning, good afternoon, or good day, whatever it is for you watching this video. Today, Ashley and I are going to be presenting to you a great educational seminar on buying a tenanted property. So recently, there's been this great series on Netflix called Worst Roommate Ever. I know that you watched it, Ashley. What did you think of it?
Well, I think that I would think twice about having a roommate personally. It's a little bit scary. I realize it's a TV series, but these things do happen to people. So not a position I'd put myself in, I don't think.
Gotcha. Yeah. When watching it was definitely interesting to see the difference in the laws that some of the states had. Now, of course, Worst Roommate Ever on Netflix is a series about roommates in the States, not here in Canada, of course, but it was just interesting to see some of those laws, how they're different. When actually watching that series, it reminded me of the Ben Stiller, Drew Barrymore movie called Duplex, which it's an older movie, but it's a really good movie. If anybody's interested in watching a funny movie about people that buy a home with a tenant in the home, it's called Duplex. Really good movie to watch. I don't know. Have you seen that movie, Ashley?
I haven't, but I'll definitely check it out.
Yeah, you definitely should. It's a fun movie to watch. So moving forward, we're going to be presenting to you what it takes to buy a tenanted property. You obviously know me. I'm Geoff Rabideau. I'm the principal lawyer and owner of Rabideau Law and Custom Closing. I've been a practicing lawyer now for over 13 years. In that time, I've completed over 15,000 real estate closings, purchase, sales, refis, investment properties, commercial properties, subdivision developments, the range, land titles, registry systems, paper, electronic. I've seen it all in that time. Or if I haven't seen it all, if a file comes to me, I want to see it all. I'm really interested to learn and take on those interesting cases. In terms of volume, I'm the number 19th lawyer in all of Canada. So in terms of volume, my firm is continually growing. We believe that we want to grow. Hopefully one day we'll be number one. But as long as we're number one in the hearts and minds of our clients and our referral partners, that's what matters most. And we have a really healthy, a really great Google rating of 4.8. I think that's indicative of the great team I have and the great work that they do. Now, prior to COVID, we were the law firm that pioneered the custom closing process, which was the process whereby we would send commissioners out to our clients' home to sign on tablets, and therefore the clients didn't have to come into the office to sign. Obviously, with the advent of COVID and the concerns about the fear of that, we then pioneered and led the revolution for the virtual signing process, whereby we'd actually use our virtual signing software to sign our clients up. So this way the clients didn't have to actually leave their home. So things that we've done, obviously, is strive to make it best for our clients, convenient for our clients, make that the best experience possible for our clients. Now, I'd like to introduce you to Ashley Friel. Ashley is a paralegal. She is the principal paralegal at AF Paralegals Professional Corporation. Ashley's been providing legal services for over 3.5 years. She deals primarily with landlord and tenant board issues, as well as small claims court. She was actually the gold winner in the Sudbury Community Votes Best Notary, and she also won the silver for the Best Paralegal in the Sudbury Community Votes. Ashley, just like myself, is fully bilingual in French and English. Ashley is a paralegal that I actually have been working with for quite a while now, and she's the one I refer to when it comes to landlord and tenant issues, as well as small claims court issues. I am competent in my abilities, but I know that she's even more competent than me in those areas, so that's why I refer to her. So thank you very much for joining me today, Ashley.
Thank you for having me. I'm very happy to be here.
Thank you. Appreciate that. So starting off, of course, as the lawyer, I have to say it, and Ashley and I are both in the same mindset here. Everything we are saying today is for educational purposes. You cannot rely on anything we are telling you. If you want more information, you can come talk to us individually. We will have our information here at the end for you, but we're always open to talk. We're always open to help you out, right? That's why we do these. We're here for you, to help you, but please, once again, this is a disclaimer. You cannot rely on anything we say as legal advice. So the topics that we're going to be going through today, the overview is buying a tenanted property. We're talking about case studies. So we have some really great cases that we want to go through with you, some interesting cases that we know you're going to find exciting. And then we want to talk about the best practices for realtors and sellers. Buying a tenanted property, of course. So buying a tenanted property has its benefits and pitfalls, right? As anybody who's who's a landlord, you know there's some great advantages to having a rental property, as well as there's some certain pitfalls to having a rental property. Now, residential properties fall under the Residential Tenancies Act, and the Landlord and Tenant Board give both landlords and tenants clear and definitive rights. It is important to know that when you are buying a tenanted property, the purchasers will inherit the tenants or the occupants, and the purchasers will assume the existing tenants with their current leases and current terms of the lease. So that what that means is if they have a lease that is 20 years old and the rent is quite far under market, and a new purchaser comes in to buy that property, that is the tenant and the terms that the new purchaser is taking on, inheriting. So tenants, as I mentioned, have rights under the Residential Tenancies Act, and certain rights with respect to when a property is being sold. So a tenant must be given at least 24 hours written notice of any showings. These showings can only happen between 8 a.m. and 8 p.m. There was a lot of complications over COVID, right? So obviously when COVID started, there was a lot of fear over COVID, and there was concern. And so what happened was a lot of showings were being rejected by tenants. Now, this was not allowed. The law was very particular on this. The showings were allowed to happen provided there was 24 hours written notice and provided the showings were between 8 a.m. and 8 p.m. Now, it is important to know that the landlord or the realtor, whoever house, had to take the health and situations of the tenants into consideration, had to take their schedules into consideration, and had to also take whether or not they're immunocompromised into consideration when scheduling these showings. And as I talked about, the existing lease will remain in effect after closing, and the new purchasers will inherit the tenants.
So COVID was something that affected a lot of people in a lot of different ways. One of the big misconceptions was that because COVID was going on and the government had put certain measures in place for safety reasons, that just meant that tenants could blanketly just refuse showings. And while we understand why people might be inclined to think that, it's actually just a misconception, because realtors were told that they had to follow certain protocols, hand sanitizer, masking. At one point, I know that they were wearing gloves. There was a limit on how many people they could bring into the residence with them at a time during showings. There was a protocol to ensure that there was enough time between showings to make sure that it could be properly sanitized. And so showings were allowed to happen, but we just had to take a little bit extra care than what we did before COVID. And I think that because there are still people who are quite concerned that some of these protocols are going to continue for a period of time. I'm not sure how long that's going to be, but I think at least for the near future, when doing showings, that'll probably be something that remains.
Perfect. Well, you know what? Actually, I think that might be a great topic that we can have another discussion on in another presentation. What do you think about that?
I think that would be fantastic.
All right, perfect. Well, guys, follow up on us. We'll obviously get more presentations. I'm going to have Ashley back. She's a great expert in this area, subject expert. So we might tease you a little bit here with another presentation coming up soon. So what I want to talk about is some of the situations and questions that I often get. So purchaser wants to move into the property, but the current tenant is still on the first year of their lease, which goes until July 31st. So it's important to note that during the term of the original lease, the first year of the lease, there is, now this is all based on provided that the tenant is a model tenant. They haven't missed their payments. They're not causing problems. They're not just damaging and destroying anything. They're allowing showings to happen, anything such as that. Okay, let's just preface that right away. So in such instances, there is nothing that the seller and purchaser can do to evict the tenants, right? During that original lease, the first year, there's nothing they can do. However, the seller or the purchaser can file an N12, which is the form that is used with the Landlord and Tenant Board called the Notice for Landlord's Own Use. And this, they can put a termination date of July 31st. Once again, that's provided you've given the required amount of time, July 31st.
Quite a simple explanation, but I think it's just important that people understand that while the paperwork and the steps can be taken even while the lease is in play, that the board will not and cannot issue an eviction until that lease period expires. And so that's why, regardless of, if you still have 6 months left and you're giving this N12 early, that the termination date would still be the end of the lease period. But the board won't order an eviction before that date.
So how can I follow up on that then? That's good to know. So what you're saying then is the board or tribunal meeting can happen prior to July 31st, but the eviction notice won't be prior to July 31st.
Right. So the first step is really, the agreement of purchase and sale happens, the N12 is issued, and it's a no fault eviction notice. So it's not a notice that we're giving to the tenant because they've done anything wrong. It's simply, the purchaser needs to move into the property for their own personal use or that of a family member that meets the criteria. And so because it's a no fault eviction and there's no opportunity for the tenant to void the notice, the application can actually be filed as soon as the notice has been given to the tenant. So this means that the minute your application is filed, you're in the queue and ready for the board to schedule you for a hearing. So sometimes you get lucky and your hearing will actually take place before the termination date listed in the notice. And so what it's important to know is that even if you have your hearing before the termination date in the notice, the board is not going to give you an eviction for a date that comes before that termination date. And it's not within their authority to do so.
No. Situation number 2, the original lease has ended and the tenants are now on a month-to-month lease. So in such instance, the purchaser can ask the seller to evict the tenants by providing the form N12. Now it's important to mention that the tenant must be provided at least 60 days notice to vacate the premises. Now, this is in part. It's not actually 60 days, it's 2 full months minimum. So if the notice is provided today, March 10th, then the earliest date that can be put on the eviction notice would be the end of May, not May 10th. Is that correct, Ashley?
It is. So the termination date has to fall at the end of a rental period. And so when we think tenancies, we automatically think, oh, rent is due on the 1st of the month. It covers till the last day of the month. So this can get tricky really fast because we have some tenancies that run from the 15th to the 14th of the following month. So you want to make sure that you're giving your proper notice, your proper 60 days notice, but it has to fall on the end of the rental period. And sometimes that doesn't mean that it's the last day of the month.
Situation number 3, the unit is tenanted at below market rents and the purchaser wants to rent it out to new tenants who will pay more. So once again, provided the tenants are not in default and our model tenants are not causing any problems, there is nothing that the purchaser or seller can do to legally evict the tenants or to increase the rent.
I think that sometimes parties try to get creative. And of course, later in the presentation, we're going to talk about some really interesting cases where parties did try and get creative. But of course, we have to discourage those kinds of behaviors because the consequences are not fun when that happens. But they get to stay and the terms don't change, just like you've already mentioned.
So we're going to talk about solutions. So the first solution when buying a tenanted property is the purchaser or an immediate family member can move into the property provided they plan on residing there for at least 12 months. And the form they use for that is called the N12, which means notice, which is titled Notice for Landlord's Own Use. Another solution is, and I've mentioned this to several clients, negotiate with the tenants and provide them with a monetary settlement for them to leave the property. If they do, get them to sign a form N11, which is called Agreement to Terminate Tenancy, as well as, and this was Ashley's suggestion, great suggestion, thanks Ashley, as well as get them to sign a full and final release.
So I think the most important reason that I made the suggestion about the full and final release is because it it really makes it clear that it was the intention of the parties to sign the N11. It outlines, the confidential terms of the negotiation, and, the parties make promises to each other that they're not going to do anything to harm the other's reputation. But it also makes it clear that this is in full and final settlement of any potential claims. The tenant isn't going to try and come back and reclaim rights to the unit. They're not going to try and come back on a tenant application, of any sort. And so it's really important. And there's also a lovely clause, as there, I'm sure, many documents have, that confirms that the parties that are signing this agreement, they understand the agreement in its entirety. They understand that it's a legally binding contract. They've either taken it to council, or they've decided that they're not going to do that, but that they're signing it voluntarily, and they understand the consequences of being bound to that agreement. And that's an important reason why I ensure that a full and final release accompanies the N11s in these kinds of situations.
Yeah, it was a great suggestion. Thank you. Now, what we have here is the actual form. So we see this is the N12 form, which is the notice to end your tenancy because the landlord, a purchaser, or a family member requires the rental unit. So that's the N12. And on the other side here, which we see is the N11. This is the agreement to end the tenancy. Now, these are the two forms Ashley and I just mentioned. So once again, N12 and N11.
So one thing I want to make sure is clear: tenants don't have to sign an N11 if they don't want to. So tenants in Ontario have the legal right to wait for the landlord and tenant board to hold a hearing and to order an eviction. And so this is a legal right that we can't take away from them. And so you'll get lots of tenants that will be more than cooperative when you're trying to sell your property. They'll accommodate showings. They'll even make sure to the best of their ability that they've made arrangements to move out of your unit before the termination date in the notice. But it's important to know that they don't have to. And so all you can do as a seller or as a purchaser is make sure that you're taking the appropriate steps to follow the board's process. And as long as you do that, you will eliminate any unnecessary delays or additional stresses.
Now, let's talk about the law. So when buying a tenanted property, there's section 49 of the Residential Tenancies Act, which we call the RTA, okay? Residential Tenancies Act. So in this instance, section 49 is the section of the law you're going to refer to. And it talks here about a landlord of a residential complex that contains no more than 3 residential units who has entered into an agreement of purchase and sale of the residential complex may, on behalf of the purchaser, give the tenant a notice terminating the tenancy, and that's that form N12, provided the purchaser, now this is very important, in good faith requires possession of the residential complex or unit for the purposes of the occupation by themselves, their spouse, their children or parents, or anybody who might provide care to any of those people.
So it's important that we understand, and I'm so happy to see that we bolded the words good faith. So good faith is important when we're talking about the genuine intention to actually reside in the property. And it's important that you understand that the courts have decided that as long as the person's intention to live there is genuine, that their motivations for wanting to live there are not necessarily relevant. And any plans that they might have while they live there are also not necessarily relevant, as long as they do have a genuine good faith intention to live there.
Now, what we see is section 49.1 sub 1. And what this is it indicates that if in the event the landlord or the purchaser is going to serve an N12, then what happens is that landlord shall compensate the tenant an amount equal to 1 month's rent, or they shall offer the tenant another rental unit that is acceptable to the tenant. And so this is even if the landlord gives the tenant the notice on behalf of the purchaser.
So that didn't always used to be the case. There was a time where if you were serving on behalf of a purchaser, that the compensation component did not apply. In July of 2021, the government enacted legislation to amend the RTA and ensure that tenants that are being asked to leave because a purchaser wants the unit also have to be compensated. So that is a fairly recent change, but it is one that we now have to account for when we're dealing with these types of situations.
When paying this compensation, what are the options that a landlord has in order to pay this compensation?
That's a fantastic question. So before I answer that question, it's really important that everyone understands that the compensation must be paid before the date in the notice. So that termination date is your deadline for giving this compensation to your tenant. I would also like to make a note and make it clear that it doesn't matter if your tenant is in arrears, if they owe you any money. It doesn't matter if there are, allegations of damage on the side or anything like that. That compensation is owed to them. That doesn't necessarily mean that you have to give them cash or cut them a check. For example, you could waive a month's worth of rent, but you need to make it clear to the tenant that when you're waiving the rent, you're waiving it to have it satisfy the compensation requirement under the act. And so often what we do is we would write to the tenant, we would explain that pursuant to the RTA, they're entitled to 1 month's rent's compensation, and therefore in satisfaction of that requirement, please do not pay rent for April 2022, for example. That will count as your compensation. And as long as you can demonstrate that you've made it very clear to the tenant, then it will satisfy the requirement.
Okay, so if we take that scenario a little bit further, let's say a tenant paid first and last month's rent. Let's say the landlord gives the tenant the required 60 days notice. So in that case, the landlord could say, you don't have to pay any rent for the last 2 months because the last month is covered by the last month's rent and the second last month would be covered by that 1 month's compensation.
Well, in an ideal situation where your tenant has communicated that they're going to be out by the termination date, then that would be absolutely correct. But the last month's rent can only be applied to last month's rent. So if it's a situation where the tenant intends to stay in the unit until a hearing, then their last month's rent deposit has to stay on hold for them until it's been determined that they're going to be leaving. And so I would be cautious about how we phrase that to the tenant, because we would not want to give the tenant the impression that from now until you leave, you don't have to pay any more money.
Gotcha. Well, that's probably a best practice for realtors and sellers, that you don't want to chase money. Obviously, you have that last month's rent deposit on hand. It's best not to give it away and you can't give it away. So how would that work in the instance where let's say the tenant says, you know what, I'm going to move out in 60 days notice. The landlord turns to the tenant and says, okay, fine. April's rent you don't have to pay, and May will be your last month's rent. What then happens in that instance is if the tenant doesn't move out at the end of May with respect to that last month's rent, does the landlord now have to go back to the tenant and say, hey, you owe me that last month's rent back? How does that work?
So if you're accepting notice from your tenant that they're vacating, you really should be having them put it in writing. So the N9 form is actually a form that tenants can use to provide you with written notification that they're going to leave. And so I would recommend that if you're receiving notice from your tenant, that before you make any allocation of that last month's rent deposit, that you have it clear in writing that it was applied because they said they were leaving. If they turn around and don't leave, and you have that N9 document that was signed, then you would also have some other options available to you, which are not really in the scope of our presentation today, but that would also be another topic that maybe we could throw into another presentation.
All right. I love the little teasers we're throwing at our viewers here. So another opportunity there to learn more information. Come back soon. Okay, guys. So the leading cases, obviously Feeney and Noble, which is a 1994 case, and Fava and Harrison, which is a 2014 case. And the cases have come out and said that based on a balance of probabilities, the landlord purchaser must show a genuine intention to occupy the premises. Now, genuine intention obviously means, as Ashley has told you, there really has to be an intention to move into that property, hence the word genuine intention. And then the cases have, and I believe you would agree with me that Fava and Harrison has said that in order to determine the genuine intention, the courts have taken into consideration the conduct and the motives of the landlord and purchaser. Would that be correct?
Yeah, absolutely. Sometimes things are not as they seem, right? And to tie it back to your comment about, you know, the Netflix series that we watched about worst roommate ever, none of these people that got themselves in that kind of situation had any idea about what was coming to them. And this is very similar. So sometimes things are not as they seem at face value. And so the board is allowed to consider the circumstances as a whole, because that helps to determine whether or not the genuine intention to move in was actually the proper motivator for the issuance of the notice. And there are some situations, which we will talk about as we get through the next slides, but where the board makes a determination that this was not actually the intention.
Yeah, and as you point out, this is a question of credibility as determined by the member of the tribunal at the time.
Absolutely.